what we're including today is we're trying to sort of widen the remit and ask the question really, how do we identify the correct defendant in a road traffic scenario? And so I think, we can perhaps argue there are a number of options. Do we possibly think about the driver's employer? Do we think about the insurer? Maybe we think about Regulation 3, European Community's rights against insurer regs. Do we need to think about whether an insurer might become an Article 75 insurer? And what does that mean? And also, I think, thinking about what exclusions there might be in any insurance policy, RTA insurance policy, that the defendant has, and possibly the wider remit of other types of insurance. And obviously, in relation to that slide that we're looking at now, driver's employer, clearly it might well be that we're not proceeding against the RTA insurer at all, and that we are thinking of proceeding against the employer's liability insurer. I wanted to do this webinar because I think it will bring us up to date on the real impact of the case that caused so much discussion, and that's the Cameron and Liverpool Victoria Insurance case that went to the Supreme Court, it must be about 18 months ago now, actually, about suing unnamed drivers. And just looking at that, situation, where are we at now? We know post Cameron and Liverpool that we're in a situation where it's no longer an option to sue an unnamed driver. We don't know the name of that driver. It's just not an option to proceed that way. So we need to think about where are we? What options are left to us? So what are the consequences? Well, the consequences are that claimants who brought proceedings against unidentified drivers have had to discontinue their claims effectively or face strikeout, and instead pursue claims against the Motor Insurers Bureau under the Untraced Drivers Agreement, and that victims of RTAs of this kind are not going to benefit from the same cost regime applying to litigation, but they will gain the benefit of a scheme or a system, the Untraced Drivers Scheme, that is designed to ensure they're going to be compensated, if you like, in a timely manner. So I think if claimants had been able to obtain judgment against the unnamed defendants, then pursued the motor insurer by way of relief, the sort of significant potential for fraud would arise on the basis that there were lots of proceedings against unnamed drivers without MIB investigations being involved. So, it's easy to see how this situation arose and how, from the point of view of the Motor Insurers Bureau, that protection was created so that unidentified drivers couldn't be sued with all the difficulties that would bring for insurers.